So good evening. This is a good day, and particularly a good moment to celebrate the principles of open society, where we are gathered here at the Open Society Archive, and we'll discuss some of the most cutting-edge, exciting issues having to do with open society today. I want to start by congratulating the Open Society Archive and my friend and colleague István, the director, and the Center for Media and Communication Studies for having the foresight to plan this event and even to reschedule it so our distinguished speaker could escape from New York, where the last time he was, I think, in about 3 feet of snow. So we were unable to have that event at that time. I'm very pleased to welcome David Mcgraw, our distinguished speaker, whom I will introduce in just a moment. But let me start by just saying a few words about the sort of backdrop of this event. I think we all certainly know we live in the age of the internet, but we also live in the age of the internet revolution. And what we have seen, I think, here at CEU, as recently as September of last year, was an earlier celebration of some of the aspects and concerns, I wouldn't say just celebration, but exploration about what happens on the internet. What is freedom of expression on the internet? How does it work? What is its implication for democracy? What is its implication, above all, for freedom of speech, and how are the censors at work? And I think that conference, which was attended by scholars and activists from all over the world, really reflected some of the cutting-edge issues which, over the following 4 months, were played out in great detail and in dramatic form across the world. Certainly the internet-driven revolutions in the Middle East that are underway at this time, and then the media and publishing revolution that was brought about by the Wikileaks disclosures and publications, which we'll be exploring here tonight. Last week, CEU was very pleased to be able to host an open forum on the issues regarding the Middle East, and tonight we're especially pleased to work with our colleagues at the Open Society Archive to sponsor this exploration of the WikiLeaks revolution. There are, of course, many themes to explore and many questions to ask. Certainly the role of secrecy in foreign relations and the conduct of foreign policy, the role of the internet in piercing the wall and the veil of secrecy, the historic role of the mainstream media in publishing information and government secrets that the people have a right to know, and the new role of internet actors like WikiLeaks in working with the mainstream media, which of course is what we will hear about tonight. Then the historic role of the law, particularly in the United States, in protecting freedom of the press and freedom of speech, but also providing some measure of secrecy and protection of secrecy, and how that law may be changing under the relentless pressure from the internet. This is a very special interest of mine because in my early days as a civil liberties lawyer, I was involved in some of the cases. I was telling our distinguished speaker a case involving the New York Times and the publication of papers about the Vietnam War called the Pentagon Papers. And later on, as a litigant, as a lawyer representing scholars who were seeking information under the Freedom of Information Act, I was pleased to be able to produce some 75,000 pages of FBI documents many, many years ago when it was possible, and it still is in many ways, to get that information under the Freedom of Information Act. Our speaker tonight is a major player in this drama, and certainly in the WikiLeaks drama, but he is a very distinguished lawyer. He's the vice president and Assistant General Counsel of the New York Times, one of the world's truly great newspapers. I would say the world's, in many ways, greatest newspaper. He's the lead counsel for the Times in newsroom issues and freedom of information litigation. He has been successful in many lawsuits in obtaining thousands of government documents, including documents relating to the 9/11 efforts to rescue people from the World Trade Center, documents relating to the secret campaign by the Defense Department to influence public opinion during the Iraq War. He's been a consultant to drafters of freedom of information laws in a number of countries, and he has led workshops on press freedom in the Middle East, in Central and Eastern Europe, and in South America. So it's a great privilege for us here at CEU to welcome David Mcgraw to our university and to this exploration of open society. Thank you, David.
Thank you, John. Some of you who know me from this is my third trip to Hungary, so I'm delighted to be back. Some of you know me from my previous presentations know that one of my claims to fame is that I was the first non-Hungarian American lawyer to become a New York Times lawyer. Before I came, the two lawyers were Hungarian Americans, Adam Liptak, whose parents were Hungarian, and George Freeman, whose parents lived in Hungary. When I applied for the job, I thought I was advancing the employment opportunities of Scottish Americans, and thought that was an important move forward. I think at the Times they thought it was a lowering of their standards to not go with another Hungarian. But I assured them that I was very pessimistic about the future, and I feared that my freedom would be taken away at any moment. So even though I wasn't a Hungarian, I thought like one. And, what I'm going to do tonight is talk sort of in a narrative about my role and how the Wikileaks story unfolded at the New York Times, and then talk about what I think of as for the lessons or for the concerns that come out of it. And then I'd like to have someone from the archives speak briefly about some of the things that are going on here, and then take questions, because I'm sure that there will be lots of questions, and I'm glad to answer those. I should say that obviously, because this is still a matter that technically has some legal components, I may give answers that are less than full, so I don't invade attorney-client privilege, and because I usually try to avoid hard questions. But I also should explain before I begin that the role that someone in my position plays, I'm an in-house lawyer for the New York Times, and one of the things that I think of is an important part of press freedom is that journalists should have lawyers out of their hair as much as possible. That a sign of a country that has great press freedom is that you as a journalist don't have to worry that often about what your lawyer's thinking. So many of the decisions that get made were properly made by journalists because they were really about fairness, about our role in society and so forth, and not necessarily about legal issues, although it took us a while to figure out where that line was drawn. It's often said that by many journalists in the United States that the legal department is where stories go to die, that you send your story there and lawyers tell you can't publish them. The New York Times has always prided itself, the New York Times legal department has always prided itself on being the place where stories come to live. So we're always trying to find a way to get stories in the paper, not keep stories out of the paper. So this WikiLeaks story for me, at least as it relates to personally and at the New York Times, begins on June 23rd. As I was leaving the oral surgeon, I was standing in the reception area. I was in the middle of having a tooth implant, and my mouth was filled with gauze and I was bleeding when my phone rang. I picked it up, and it was the secretary to Bill Keller, the editor of the New York Times, who said that I probably wanted to come to a meeting. I explained to her that my mouth was filled with gauze and that I was bleeding, and I was at the oral surgeon. She thought I still should come to the meeting. So I went to the meeting, and as I was passing through the newsroom, I decided that if I was going to have to show up for whatever this meeting was about, no one had told me, that it's probably not a good idea to come with a big wad of bloody gauze. So in violation of health standards in the workplace, I threw the gauze out and went in, where I can safely say what I heard made me continue bleeding for the rest of the day. If I ended up back at the oral surgeon to try again, it was that kind of stress. Basically, I came to a meeting a few minutes late, but was in progress with 5 or 6 journalists and some other journalists on the telephone in Washington. And it became clear that we had heard from The Guardian in London that they wanted to share with us a set of cables, a set of documents from Afghanistan. They were situation reports and intelligence reports that the Department of Defense had gathered and which had been leaked to Wikileaks and was being passed at some point to The Guardian. And The Guardian was looking to have us join in this effort, as well as Der Spiegel in Germany. And at some point in that conversation, all eyes turned to me and say, "What do you think?" Now, what I'm thinking is I'm bleeding and that I should have not thrown that gauze away. I mean, I look like a fighter with bloody teeth, and I really think that this is a very troubling idea, except that I really haven't done much looking into it. Everything I know, I've now known in the 5 minutes I've had to hear about it. But I can tell you from working with journalists, you know when there's only one right answer. When they ask you that question, they're not looking for you to say, no, this is a terrible idea, let's go back and cover traffic accidents in Queens. They're looking for you to in fact say that it seems like an idea we can work with. And that's really what I said and what I thought was that that we should get these documents. I remember having a thought that would come back to haunt me, because it had been well known that Bradley Manning apparently had leaked, it was reported initially 150,000 diplomatic cables. We later came to understand it to be more like 250,000 diplomatic cables. And I remember sitting in the room thinking, documents from the Defense Department about the war in Afghanistan. Thank God it's not those diplomatic cables, because that would really be a problem. So off we went. The newsroom dispatched a reporter named Eric Schmidt, a very first-rate Defense Department reporter, to London to meet at The Guardian and see what these documents were about. There were 77,000 incident reports and another 15,000 intelligence reports, so 92,000 documents. Meanwhile, we set up a tech team of reporters whose job it was to begin figuring out how to make these documents searchable, because the whole idea here was to pull out stories, not to do volume publishing, but to put these into context, to understand what they're about, to try to identify wider trends. Meanwhile, I was off to begin trying to understand the legal climate and the legal perspective here. And the thing that I want to stress is that at this point, it was really unclear what the government would do, how it would react, what sort of legal threat there may or may not be. And I'll get to in a second to sort of the big picture here, violation of Espionage Act, the law in the United States which governs the publication of secret documents. But there were a lot of other things that were crossing my mind, and with my associate, Jake Goldstein, we began looking at them. But part of it was things that, in this initial stage, that concerned us. Part of it was, how are we going to safeguard the files internally? Was there a problem in possessing them? What did the law say? Even if we decided not to publish at some point, was there a problem in possessing it? We looked at broader issues too. We are a publicly traded company. We trade on the New York Stock Exchange. Was there some obligation to inform our board? Did our board, if there was a possibility of criminal liability by the company, should the board be involved? What if we got the board involved and one of those business people decided to resign in protest or to turn us in or take any other step? All of those concerns we begin thinking about. We were concerned about individual liability. You know, we were asking employees in a company to do something that had legal implications. Should we be concerned about individual liability? Did we have to give people the option to opt out? Could we, in fact, tell people this was part of their job, and if they said, this doesn't feel right to me, this may violate the law? Were we required to let them out? I received a call at one point from somebody who was deep down in our tech team working on the search part of this. One of his workers was working on a visa, was in the country on a visa. Did he have to worry that his visa status would change? Those kind of questions we hadn't anticipated having to go to, but we did have to go to. But we were also concerned about the broader question. What had WikiLeaks done, and was there a possibility we would be seen as aiding and abetting? We didn't really know much about WikiLeaks at that point. There was one big profile in New Yorker magazine, but we really didn't understand a great deal about where they were coming from and what had happened to get these documents, which had passed from The Guardian to us. We also worried about our association with The Guardian itself. We love The Guardian. We've partnered with The Guardian in other things in lesser ways. But The Guardian exists in a very different legal system. In the UK, in England, the press is constantly laboring under the threat of getting an injunction preventing from publication. That's not what happens in the United States. It's very hard to get an injunction. Would we be seen as a co-publisher with the English newspaper? And if an English court enjoined The Guardian, would it also enjoin us? And if it enjoined us in England, would we have to honor that? Very difficult questions. What would it mean to have an English court tell us we couldn't publish something? Could they, in effect, issue a court order that would reach the United States and ultimately reach everybody in this room and everybody else who wanted to read the New York Times? We even looked at the question of what would happen if our reporter carrying the information back into the country on electronic media was stopped at the airport. What was the right of a reporter passing through customs in the United States? The answer, by the way, is you have a lot of protection if you're willing to stay at the airport for about 5 days and argue the law with somebody. You really don't want to be stopped. But the main concern was the Espionage Act, which was passed initially in 1917, amended after that, but is a very complicated and dense statute. It has many provisions. It was written at a time well before computers. And it continues to be a mystery as to when it would apply. Does it apply to journalists at all? And if so, when? What are the conditions in there? When you read the Espionage Act, what you find is that it can be read so that it's breathtakingly broad, okay? For instance, it appears that you can be prosecuted under the Espionage Act for disclosing secrets, government secrets, even if you had no intent to harm. You can be prosecuted even if no harm actually occurs. You can be prosecuted even if the information that you disclose shouldn't have been labeled a secret. In other words, if the government has labeled something that's in the public domain secret and you publish it, you can still be subject to liability under at least one reading of the statute. And significantly, it applies not merely to publishing, but to the receipt and possession of information. Now, why is that significant? It's significant in the United States because the broad and strong protection of the First Amendment applies to publishing, not to news gathering, not to possession, not to receipt. And so there was concern that while we might have a First Amendment argument of our right to publish no matter what the espionage said. Less clear is the question of whether we had the right to possess documents. But here's kind of here is sort of the headline on the espionage. In its entire history in the United States, no reporter, no journalist, no media organization has ever been prosecuted. In the entire time it's been there, no one has ever been prosecuted. That includes, no journalist has ever been prosecuted. Leakers have been prosecuted. There was an attempt to prosecute some lobbyists who got information and then were leaking it, but no reporters, no journalists have been prosecuted. The other important thing to keep in mind about the way the statute work grows out of the Pentagon Papers, which John was just talking about. The Pentagon Papers were a secret U.S. government study of the Vietnam War, leaked to the New York Times, which began publishing them, and the government responded by going to court and getting an injunction, seeking an injunction, getting an injunction first and seeking to make that injunction permanent so the New York Times would not continue publishing. And in a famous decision by the Supreme Court held now almost 40 years ago that injunctions were almost always going to be illegal in the United States, that unless the government could show clear and present danger, we had the right to publish. Now, what many people forget about that decision, which was a great decision for press freedom, is what the justices actually said, which is, government, if you want to prosecute the New York Times for publishing that, there's probably grounds for doing that, but you can't stop them from doing it. In other words, newspapers who publish secrets risk being criminally prosecuted, but the government can't prevent them from publishing it. This creates an interesting dynamic for somebody in my shoes, because if you think about it, sort of picture yourself in my position. I'm now advising the newspaper on should we publish this or not publish this. And the dirty secret, of course, of media lawyers is injunctions are actually much easier, right? If you get enjoined, you've gone into court, you've argued for press freedom, you lost, you can be angry at the government, you can be outraged by this intrusion on press freedom, but you know what? Nobody's going to jail. There's a court order that says you can't publish, and so you can feel angry and upset and you can rail about it. Now consider the other possibility, which is how the US law works. No injunction, but if you make a mistake, somebody's going to get arrested. And the first thing they're going to ask is, lawyer, why didn't you tell me that? So that really became part of my role, was to first make people aware that, one, the Espionage Act isn't clear. It may apply to the press. Justices of the Supreme Court have said that. It has never been ruled definitively. But second, and I thought this was sort of the key piece, is that there's never been a prosecution. And in talking to colleagues who've come across this and in the previous times we've dealt with this issue, the thing that I always think is important is that we not take any step, that we not do anything that would make prosecution likely. Okay? Well, you don't want to create a culture around your publication where, for the first time in history, this administration is going to decide to prosecute. And so some of the things that I think people should think about in these situations are, are the stories we're doing in the public interest? Because if they're in the public interest, there's not going to be the political climate to prosecute. Are we careful to make sure that we're not causing harm to individuals? We're going to make sure that we redact out the names of people who may be in danger and aren't necessary to the story. I wanted to make clear, and I've advised people this in any context, make sure you create a source relationship with your source. That is, you're not a partner, whether that person is someone who's speaking to you about local government or is talking to you about something that's happening in the police department or Wikileaks. they're a source, and that you maintain a reporter's distance from a source. That's good journalism. I also think that it's important as a legal construct. I thought also, and continue to think also, that we made absolutely the right decision at the New York Times in talking to the government before we published. We did not give the government the right to censor us. We did not give the government the right to tell us what to publish or what not to publish. But there was a conversation before each of the 3 releases where we were very straightforward with the government about what we intended to publish, and we heard them out about what it was that concerned them. Now, obviously, the government's position throughout this, for all 3 sets of documents that were released, that we published from, was that we shouldn't do this. This was a bad idea, that this was not right. But in the end, they did engage in a conversation and raise concerns, which we'll talk about a little bit more after this, or in a few minutes. But I thought that that was an important step to show that we were open to that conversation, that we were not being reckless, that we were trying to be careful at the same time, doing our duty to our readers to tell them about very important matters of public concern. So we begin down this process the first time out, and again, in these opening days, we still had no idea how the government was going to respond. And so, at one point, I went down to the 5th floor of the New York Times building, which is a part of the building that the reporters normally aren't on, and there was this amazing scene of our entire staff, pretty much from Afghanistan and Pakistan, our entire reporting staff, and from Baghdad, had come home. And so you walk in and you see all these foreign correspondents sitting there with these 23-year-old geeks working their computers because they were in charge of actually doing the technical redaction. And so the reporters are there looking over their shoulder saying that should be redacted, that can come out, concerned about that. And it was really quite an extraordinary effort. Chris Shivers, one of our best war reporters and a former Marine, was in charge of much of the redaction. At one point, he redacted, who would have thought of this? He redacted the time that it took a helicopter to go from point A to point B in Afghanistan, because he thought that was information that could, in fact, endanger U.S. lives if the Taliban was able to know from what base they were coming from and how long it took to get there. So we were very serious about that and very serious about trying to make sure that those documents were redacted. We'd not yet gone to the government as July 25th approaches. July 25th is been set as the publication date for The Guardian, Der Spiegel, and the New York Times. The way this was supposed to work was that we would all go online at the same time. We'd all release our stories online at the same time, and Wikileaks would post the documents in raw form. So about 2 days before that, finally, one of our reporters and one of our editors went to the White House to tell them what we intended to do. And there was a sense of relief when the message came back that the government's response was not to threaten. The government's response was to say, I hope you're going to handle this sensitively. We'd prefer you didn't publish it, but we understand what you're doing. And if you're going to publish it, we'd hope that you would keep in mind that people could be endangered. And that was kind of the sigh of relief legally, that I felt that A, we were doing the right thing by talking to the government, and B, that the response was not going to be an attempt to try to get an injunction, even though that would be hard, or to threaten us legally with criminal prosecution. Now, we're still not quite sure how this is all going to work, and the plan is, of course, that WikiLeaks is going to put up the documents in raw form on their site. There's 92,000 documents. We were, in fact, planning on publishing 25 documents after we edited out things that we thought were sensitive. The Guardian and Der Spiegel were putting up a few more, but again, they were putting up a limited number. But the whole thing had been premised on the idea that if WikiLeaks put them up, that actually was sort of made us less of a target, if you will, because those documents were out there. And the decision was made that it's Sunday on July 25th at 5 o'clock that we would publish. So I was down in the newsroom, and people are running around putting up the finishing touches on things, doing headlines, documents are ready to go, and 5 o'clock comes, and someone is assigned to look at Wiki's site. And as often happens with WikiLeaks, if you ever go there, at 5 o'clock, their site is down. It's not operative. Okay. So at 5:05, I'm told that the Guardian is up, that they have posted. This is not just for my interest if I want to go read it. That is, would you tell us that it's okay to go? So as often in life, I say to myself, let's wait and see what the Germans do. So it works generally. So about 5:10, someone announces Der Spiegel is up. Okay, and it's obvious now that it's now become my personal problem. And I keep hoping that whatever technical problem they're having at Wiki is solved. In my mind, I'm thinking this is Julian Assange's revenge, that he's actually suckered us into publishing this stuff and he's not actually going to do it. But at 5:15, we decide that we'll go ahead and publish, and up go our stories. We then, about 15 minutes later, there's an announcement that WikiLeaks is going to hold a press conference, which didn't make me feel much better. But ultimately, about, I think an hour later, they actually get the documents up. And I think it's important in telling this story to watch how WikiLeaks changes. And as some of you know, WikiLeaks now is sort of in a bitter feud with us and with The Guardian. But the first time, so there's three sets of documents, right? There's the Afghan documents, which go up on July 25th. There are the Iraq documents that go up on October 22nd. And then on November 29th, there are the diplomatic cables. And the story's based on all of those. In the first release, Wiki did not redact, okay? When you look at the 77,000 documents, the 77,000 incident reports they put up, they did not redact names. The three publications did. And after that, WikiLeaks was heavily criticized by people that they saw as their allies, Reporters Without Borders, Amnesty International, the Committee to Protect Journalists, because they felt they had endangered everyday Afghans who cooperated with the United States and had provided information, and that those people were in jeopardy for retribution from the Taliban. They felt that criticism. And in the next round, when the Iraqi documents were put up, Wiki went to the opposite extreme. They actually had an auto redaction, an auto editing program that went through all the documents and took out the names. Okay? Historians and researchers tell me that those documents are now worthless because you have no idea who they're talking about or what they're talking about. That the over-redaction is so significant that those documents are no longer of much value. We did what we did the first time, as did The Guardian and Der Spiegel. That is, we made redactions of people whose lives may be in jeopardy or who had other privacy concerns that didn't really affect the overall story. Well, you can imagine on Wiki's side of the world, this is concern. First they get criticized by NGOs and human rights groups for not redacting enough. The second time they get criticized for redacting too much. Meanwhile, the mainstream media, the hated mainstream media, is being treated like heroes for being sensitive and responsible. So Wiki, the last time, decides that it will not redact, but instead only publish articles, only publish the cables that one of the mainstream media participants has put up. So if you look at Wiki today, even though there are 255,000 documents that they have, they've only published about 3,800. And they will only publish, so far, those that first have appeared on the New York Times site, or The Guardian, or El País, Le Monde, Der Spiegel. So in effect, they have adopted the viewpoint of the mainstream media. If you sort of think about them having started as sort of the hallmark, the icon of hacker culture, over time they evolve into something that looks much more like the mainstream media. I should just mention in talking about 2 points. One is our relationship with The Guardian, and one is our relationship with Julian Assange, and then talk about, I guess, some of the bigger issues here. Our relationship with The Guardian has always been close. I know The Guardian's in-house lawyer very well, and we were constantly in contact. They work under a very different system. But the thing that we really parted company on was whether to go to the government. The Guardian believed that was a huge mistake, that to go to the government was simply to invite for them an injunction by the British government against them that would prevent them from publishing. And they, in effect, asked us, and we agreed, to not reveal to the United States government in advance that The Guardian had the documents. We felt that that was an awkward thing for us to do, to go to the government and then pretend that it was only us and Der Spiegel and not The Guardian. And at one point, I was instructed to call the Guardian lawyer, their outside lawyer in this case, and convince her that The Guardian should get on board with going to the US government and having this dialogue in advance of publication, something we'd done with other sensitive stories. She didn't return my call, she didn't return my call, she didn't return my call. The day was ending in England. I called again. It turned out she had been at an all-day hearing for an injunction against The Guardian over a privacy matter. Needless to say, she was not as receptive as I would like her to be to have an American lawyer lecture her on how she should practice law. So she was very polite, she was very tired, and she said thanks, but no thanks. So The Guardian chose not to participate in that. We obviously conveyed concerns that we heard from the government to our colleagues in Germany and in England. I think probably one of the interesting sideshows here is Julian Assange and the relationship with the New York Times. Julian has, at various points, decided that the New York Times is public enemy number 1, 2, or 3, depending on how you count it. The Swedish government's usually up there someplace. And he also is threatening to sue The Guardian as recently as last week. His problems with The Guardian have to deal with some statements The Guardian has made about him. But his problem with the New York Times is interesting. It began because we refused to link to his website from our website when we published the documents. We did that for a reason. We feared that he wouldn't redact properly. And we were right. Now, our readers are very astute. They know how to find Wikileaks on the internet. They know how to use Google. But we did not want to appear to embrace that, so we chose not to link to his site. He thought that was disrespectful. He also objected to our coverage of Bradley Manning, the US soldier who is accused of leaking documents. He felt that we should have portrayed Bradley as a whistleblower, an anti-war activist. We gave a much more detailed and nuanced perspective on him. We talked about his discontent with the Army. We talked about his struggle with his own homosexuality. We talked a lot about his life, the problems he had growing up in Oklahoma and Wales. And Julian thought that, again, we were not true to the cause of open expression. The breaking point, to some extent, came when we did a profile of Julian, okay? And we discussed, among other things, his problems in Sweden. And we did not take the position that the Swedish prosecution was government persecution. We took the position, as we would in any story, here's what the Swedes are saying, here's what Julian's saying, here's how it works legally. He considered that a smear job and was outraged, and he wanted to cut us out of participating. This was before the cables had been turned over. He wanted to cut us out of that. We felt, and I feel today, that his anger at us is actually a testament, in my mind, to we're doing the right thing. He is a news story. WikiLeaks is a news story. All of you are here in part because it is a story of social importance. We have an obligation to cover him, even though he is, in a sense, a source to us. We have an obligation to tell our readers about him, and to do that in a fair and balanced way without taking sides in it. He obviously sees it differently. There were other things that were outrageous, but those were the ones that were really there. So as this thing unfolds, after the first set of documents are released, the first set of stories are done, really switches away from much of a legal burden for me, because we sort of see how it's going to go. We continue to operate within the newsroom with as much secrecy as you can have in a newsroom. As most of you know, newsrooms are places without walls, so everybody seems to know what everybody's doing. And when you suddenly have three reporters from Kabul and 3 from Pakistan and a half dozen from Iraq suddenly show up, it doesn't take a very skeptical mind to think something big is happening. So I'm sure that people were aware of it and were aware that things were going on, but it really became much more after that first set of an issue for journalists, which is, as I said, is the way it should be. Let me talk about 4 lessons, I think, or 4 concerns that come out of this, which I think are worth taking note of. And I guess the first thing is that, especially in the United States, but I think elsewhere, we have to be concerned to not let governments overreact to what's happened with Wiki in a way that will bring about a curtailment and a cutback of press freedom. I think that there is a concern that, the lights have gone on in Congress and elsewhere for some people, that somehow this is unacceptable and it's caused by press freedom. And I think we have to be very concerned that we maintain the kind of press freedom we have. If you think of it, but in fairness, this is a very difficult issue. Traditionally, we have been concerned in the United States about press freedom in 3 ways, 3 main ways. One is the freedom from government control. One is freedom from libel suits that will, in fact, make reporters less likely to report. We've been very successful in making the rules in libel suits in the United States such that it's very hard to win a libel suit, and that's had a very, very beneficial effect on the U.S. press in terms of its reporting. I mean, the situation in the United States in libel, I can just give you this as sort of the marker. The New York Times, in at least 60 years, has not lost a libel suit in the United States and has not settled a libel suit for money in the United States. Okay? That's not the product necessarily of brilliant lawyering, although I wish you thought that. It is the product of the fact that the law is very much in our favor. Currently, in the United States, there is 1 libel suit against the New York Times. Okay? That is it. So there's great protection for libel. The third thing is protection of sources. That one of the things that we continue to press for is the right for journalists to protect confidential sources. We think that's important. We think that if journalists can't protect confidential sources, the public will be the ultimate losers. They won't get the information they need. So my point here is there is special protection for the press in all of those areas. Now, the question becomes, what is the press? Who's a journalist as the question gets raised? is Julian Assange protected by those same freedoms? And there's no question that the lines are, there's no question that the laws, as they've developed in the United States, have envisioned that there's a difference between reporters and sources. Sources over here, reporters over there, reporters get special privileges, okay? That there is a difference in terms of who gets a press pass. I'm talking about a simple example. Who gets a press pass? You have to be a member of the press to get a press pass so you can go to a crime scene or go to the scene of a natural disaster. But those lines are starting to break down. You now see blogs that are essentially journalism, right? They're reporting, but have none of the hallmarks of conventional mainstream media. You see citizens journalists being used not only on their own websites, but on CNN and other sites. You see Wikileaks. You see the one that the government always brings up whenever I'm on a panel on this, Inspire magazine. I don't know if any of you are readers of Inspire magazine. Inspire magazine is the magazine for jihadists. Okay, it's the magazine for terrorists. It is an actual publication, and you know, inevitably, when I'm on a panel on this, some prosecutor will say, "Do the terrorists get to assert the reporter's privilege because they're also working for Inspire magazine?" To me, I don't see a problem with that, but they do. In seriousness, you know, it does raise interesting questions. You know, so you now see this debate. Should the mainstream media essentially say Julian Assange, citizen journalists, bloggers should be protected and run the risk that that protection will be cut back for all of us? And that's really the risk, that as we sort of extend the protection, I think there will be temptation by courts and by Congress to say that goes too far, and they'll bring the whole thing back. The problem, though, is how do you distinguish between someone like Julian Assange and the New York Times reporters for legal purposes? What is that distinction? What is that difference? And so I made a list of the ones I'd seen in various articles, because people are constantly saying, you know, reporters on this side, Julian Assange over there. Some of the difference, WikiLeaks collaborated with his, you know, that Julian Assange collaborated with his apparent source, Bradley Manning. I don't know all the facts yet, but a reporter asked me, if I say to one of my sources, let's meet at a bar where no one will see us, call me from home so the phone call doesn't show up on your employer's phone records. What if I give them a disposable cell phone? Is that collaboration, or is that protected reporting? Another reason given, WikiLeaks engages in threats. You know, Julian said that if anything happened to him, he was going to release hundreds of thousands of documents, Bank of America was going to fall, so forth. Some reporter asked me, when I tell someone that if they don't talk to me, the story is going to look very bad for them, have I crossed the line? Have I threatened? Okay. Is there a difference between saying, I'm going to run this story, and if you don't talk to me, you're not going to look very good? Is that somehow different from when Julian Assange says, I'm going to publish these materials if I don't get my way? Somebody else said the difference is WikiLeaks has a point of view. They have a cause. They believe they're anti-secrecy, open government. Last time I checked, not too far from what the New York Times is saying in editorials. You know, we happen to be anti-secrecy and for openness. The fact that we have a point of view on our editorial page shouldn't strip us of the defenses we have in a libel case, the defenses we have for sources. Somebody points out WikiLeaks doesn't engage in editorial judgment. There's no synthesis, no analysis, no combining of information. They just publish raw documents. Go to the New York Times website sometime. Just last night, somebody called me because they wanted to publish an affidavit that had been filed in court, which showed somebody's financial situation who was involved in a news story. Raw document, no analysis, no commentary. We're all in that business now. So none of those are particularly satisfying, and I think one of the challenges is going to be how we make sure that the protections journalists now have are not eroded by concerns about non-conventional, if you will, media organizations. Second thing I wanted to highlight coming out of this is we need to be concerned about the protection of leakers. We need to be concerned about the protection of whistleblowers. This is a very hard topic, okay? I understand the discomfort people feel in government and elsewhere about unauthorized disclosures. I understand that. As a lawyer, I depend every day on the secrecy and confidentiality extended to me by the attorney-client privilege. I could not practice law without secrecy, okay? One of the things that I did spend a great deal of time on in 2008 and 2009 was leading our crisis management team at the Times when our reporter David Rhodes was kidnapped by the Taliban. He was held for 7 months in Pakistan and in Afghanistan. The New York Times asked repeatedly that people not reveal that he was kidnapped. We called up Al Jazeera and we asked Al Jazeera to take down a news report. We called the Washington Post, the LA Times, the Wall Street Journal. We called individual blogs. We asked them not to report because we thought the disclosure that David was kidnapped would be bad for David. David says that was one of the wisest things we did. Okay. So I understand the value of confidentiality. I understand the value of that. But I also understand that leakers play an important role in government. They're an important part of the civic conversation. And traditionally, the US government has not been aggressively pursuing leakers. That is no longer true. There are currently 5 prosecutions of leakers taking place in the United States. Government workers who have provided information. In some ways, it's a hard issue for us because one of the things we argued at the time of the Pentagon Papers case was the government has a right to try to keep secrets, and they have a right to discipline their own employees, and they have the right to expect their employees to live up to their duties. But then that's how government should protect secrecy, not by going after the press. But now we find ourselves asking the question, there still should be limits, shouldn't there? Shouldn't there be limits on when leakers are held liable? And it is a difficult issue. It's difficult politically to argue that people have a right to violate secrecy and government employees have a right to turn over documents. And it's difficult to suggest something that may lead people to suggest, well, if leakers are protected, then you should be more responsible. You should, as a press, suffer the legal burden. I think that's a false choice. I think the press should be protected, and I think leakers should also be protected. Not completely. I mean, there's no question that there are leaks that should not happen, that jeopardize, that harm, but it should be a high standard, and I'm concerned that the standard is not there, that it is too easy to prosecute leakers. If you look at, in the Bradley Manning case, essentially it doesn't matter whether those documents were in the public interest. What it matters is that he, as an Army employee, violated rules that said that he would not disclose information. The third thing that I would call attention to, that I hope will be a lesson of the Wikileaks incident, the Wikileaks phenomenon, is that the institutional media still has a very valuable role to play. It's not popular in the age of Twitter and Facebook to stand up for good old dead tree media. It's not popular to talk about why the mainstream media is still valuable, but I think that it showed here that we did something that WikiLeaks couldn't do. Put this information into context, distill it, give it a perspective, and give it attention, call readers' attention to it. It's still a valuable thing. The final big lesson I would draw from this, and I hope this isn't lost, is I still believe that government secrecy remains the great threat to democracy, not the leak of government secrets. If you sort of look at this throughout the last 25 years, very hard to find leaks of government secrets that actually caused harm to people. Very hard to see. On the other hand, it is very easy to look around and see government secrecy that has covered up human rights abuses, caused unnecessary wars, and other misguided use of government power. There is a secrecy game out there. A writer named Ted Gupp looked at secrecy, found in 1995, he found the US government classified 3.6 million documents classified or secret each year. 1995, 3.6 million. 10 years later, he found 14 million documents being marked secret by the US government. They'd gone from 3.6 in 10 years to 14 million. And as he points out, so that's 1,600 times a day, 1,600 times an hour, 24 hours a day, 7 days a week, somebody's marking something secret. It's estimated that 3 million people had security clearances to get at the same documents that Bradley Manning got to. So when we talk about secret, there is secret and then there's stuff that's just marked secret. And I fear that it's being used to cover up things that the government doesn't want us to know, and that remains the great challenge. Let me just finish on this note. I think that I haven't really proposed answers to any of those, but, and I think that that's probably a telling of where we are, that we are, as the speech was titled, in a time of information of disorder. It's breaking down who has information, who gets to keep secret, who decides, so forth. And I think that's a very confusing period we're going through as users of information, collectors of information, information providers of information. And I just end with these examples of what I see as kind of just how confusing this is for people. Shortly after the diplomatic cables stories were published by the New York Times, a very curious email went out at Columbia University in New York. Columbia University's School of International and Public Affairs sent around a notice from its job placement service telling its students to be sure not to mention the WikiLeaks documents on their Facebook page or on any other public social media because it could hurt them getting a job. And it's kind of ironic that one of the great institutions of higher learning, Columbia University, is essentially telling its students to watch themselves, watch what they say, guard themselves from free expression. That was topped only by the fact that the government itself, the US government, told its workers not to look at the documents. Okay, so you can imagine the government worker going home at night, going to a party in his neighborhood, and someone brings up this only thing that's happening in the news for 5 days in a row and saying, I can't talk about that. I don't know anything about that. They actually have notices that appear on your computer at work if you attempt to look at them. Again, the idea that the State Department thinks willful ignorance is the best perspective by which State Department employees should approach the world, I have problems with. This, of course, was topped even further by Julian Assange's outrage that the Swedish prosecutor's documents were leaked. I think that at least qualifies as irony. But by then I had gotten used to it because for me the ultimate sign of how confusing this all had become was an email I received from Julian's lawyers on December 2nd. It's marked importance high so that I will see it. And Julian's lawyers write to me, "Hi, David. I have to communicate some complaints from WikiLeaks about the release of cables, and in particular the redactions the New York Times is doing." I start. It's one of those where you sort of read it again slowly. Julian Assange is concerned that we're not redacting properly, okay? We've come a long ways. You know, when Julian Assange thinks the New York Times is not doing its redactions properly, we still have a long way to figure out where we're going to be in this world of information freedom. So thank you very much. Csaba from the archives wants to say a few words. I believe it's Csaba, right? And then I'm happy to take whatever questions you have. Thank you very much.
Thank you very much. I'm István, I'm the director of the archive. I apologize. Before you will have the opportunity to ask questions and point at the fact that we are not in the United States as far as the situation of the media is concerned, we would like to show you something and try to establish a connection between what you have just heard and this place. First, I would like to start with the fact that David Rhodes, who was kidnapped in Afghanistan, was in fact kidnapped twice. Before he was kidnapped in Afghanistan, he was kidnapped in Bosnia while covering the war there. And after he was freed, he decided to leave all the documents related to his activities in Bosnia to us. So we have his diary and all sorts of artifacts and documents from him here in the cellar. And we have an agreement with him that whenever somebody wants to use the documents that he had deposited here, we should send an email to him asking for his permission. This is what we did in 2008. And despite all the secrecy at the New York Times, despite the fact that the New York Times tried very hard not to reveal the fact that he was kidnapped in Afghanistan, we got a message from the New York Times that we are sorry, David cannot respond because he had been kidnapped in Afghanistan. But you should keep this secret. So we decided to keep this secret. The second connection between the New York Times story and this place is that Julian Assange was here in this building about 2 years ago with his deputy, who is now the founder of OpenLeaks, and he talked to one of my colleagues who happens to stand there. He came here in order to ask for support and cooperation, but at the end we decided, because of the uncertainties surrounded the way how they redact names of non-public figures, third parties, we decided that it would be against our principles to support those activities, so we decided not to do that. But the real reason why I'm standing here, and my colleague will show you something, is the following, that when Wikileaks decided to publish the 253,000 diplomatic cables, we realized that although we cannot compete with Wikileaks, we still have something similar, only 178,000 diplomatic cables, but the same types of diplomatic cables, State Department confidential central files, not from the past few years, that's true, from the period between 1917 and 1958, but something which is unavailable on the internet. A huge collection of diplomatic post reports, mostly from East and Central Europe. And since we developed a platform, the so-called parallel archive, where anybody can upload documents, we decided, following the example, among others, the New York Times, to upload those diplomatic cables. And Csaba, who is the chief archivist of the archive, is in charge of that project, and he will show you a few things.
Thank you, István. So as István said, we just 2 weeks after WikiLeaks went online with the diplomatic cables, we decided to dig out this collection of microfilms from our collections, our library collections, and we digitized them by the help of an outside contractor in a couple of days. And basically, what we wanted to do, not to publish them ourselves, but to launch a call for volunteers, to students, to academic researchers, to journalists, to everybody who was interested in the great topics of the first years of the Cold War. And so as a result of this decision, we had 10,000 documents dating from 1955 till 1959. We decided to take this period, which was rather interesting because of a number of historic reasons, the Second Berlin crisis, the Cuban Missile Crisis, and so on. And we released a call, and we set up an automatic system by which people could sign up or ask for documents which they received in an email, and then in their turn they could upload them to PA, to the parallel archive, which I will show you in a moment. Now, these records are, as was said before, are part of the confidential State Department central files and classified and cataloged according to the US government decimal system. So each and every country has its numeric code. Therefore, it's fairly easy to find by the help of this US governmental finding aid which document pertains to which country. The documents that we are publishing relate to the foreign relations of the Soviet Union and the US, and the Soviet Union with other socialist and Western countries, and they contain telegrams, airgrams, situation reports, inquiries, memoranda, translations of documents, official and unofficial correspondence sent to the State Department, and also instructions sent by the State Department to diplomatic posts across the globe. Now, we were in a much favorable situation than WikiLeaks or the New York Times, because these documents are 50 years old, and at the end of the 80s, they were declassified by the relevant US authorities, and therefore we didn't have to bother with redaction or other things. These documents carry various levels of classification, or carried at the time. Interestingly enough, the top secret documents were removed from this collection, so what we have here go as high as the secret level, and then thereunder we have confidential reports as well as unclassified but still restricted reports which bear the label of for official use only. Now, we have developed in the past years an online tool to publish and manage digital archival sources, which is called a parallel archive. And this is a collaborative online platform where researchers or users can store, manage, and do research on their primary archival sources. And we wanted to publish these documents in the parallel archive because this is a way to describe meaningfully each and every document by attaching to them a set of metadata, as you can see on the screen, including the creator, the title of the document, the author, the date of creation, the time period covered. One can add keywords and tags to each and every document by which the documents become meaningfully searchable. And also they can comment on these documents and start discussion forums on particular documents or broader research topics. Let me just mention a few more highlights of this system. each and every document is assigned a unique URL which will stay permanent as long as the parallel archive is maintained. So by using this unique URL, it is really easy to quote or use these documents as a citation, because you don't have to cut and paste text from the document. You just give the full URL as a reference. Now, the bonus feature of the system is the built-in OCR, which means that depending on the quality of the original document, you will get a full text version of the image. Thus the document becomes searchable. Now, one other thing that will help researchers use these documents is the annotation functions. And let me just see one document here as an example. This is a diplomatic cable from the embassy in Rome. It was sent in 1956 on February 29. And as you can see, these red numbers indicate that someone has done some research on this document and annotated 2 pages. And you can go back to your annotations anytime and revise them and save the new version. Now, let me just say a few words about our constituency. After an interview in a Hungarian online journal, we received more than 100 calls for documents, out of which 50 people really uploaded documents to the parallel archive. And as a result of that, now we have over 450 diplomatic cables on this platform. But compared to the 10,000 that we still have on our computers, this is basically nothing. Just to conclude, I would like to say that in order to understand these documents, one has to put them into the larger historical context. And this is something that OSA cannot offer at this point. What we do, we offer the documents, we put them out in the public domain. We give you the tool to publish these documents, and basically the rest is on you.
Thank you very much. Now, we go back to the real topic of this evening, and the floor is open, and our distinguished speaker has time, and he will try to answer the questions, and we are also open to comments as well. Please.
Thank you very much for a fascinating and really gripping presentation. My question is, how has the legal situation changed now in relation to possession of the cables? You mentioned the case of the reporter going through customs, potentially getting pulled over. I mean, if someone in this room had all these cables on their computer and went through customs in America now and was pulled over, could they be in trouble for possessing the cables?
I think the answer to that is that the question is possession of cables. Possession of confidential documents continues to be a part of a crime under the Espionage Act. Now, we have questions about how far that should go, that when a journalist has materials, that there should be some First Amendment protection. The 2 points on this. One is that as far as the airport, I mean, just for what it's worth, the U.S. government post-September 11th has broadened the rules for everybody. The search of computers is now allowed. And what the rules say is that if you believe you have a legal defense that prevents the government from going through your computer, you have the right to have a supervisor become involved at the airport. You have a right to then kick it up the ladder to higher authorities. Whether you are an attorney and you say that's attorney-client privilege, you can't go on my computer, or whether you're a reporter, and say, those are confidential documents. As I said, when I read the regulations, it sounds like unless it's really secret, you probably just want to let them look and get home. But the law is very broad in that. The second thing about possession is that, I would say, is that there's never been a request from the U.S. government to return the materials that the New York Times has. Now, one important point here is the New York Times has only posted, last time I checked, about 200 of the documents. It's about 120 cables and about 75 or 80 documents from the first two releases, the Iraqi documents and the Afghan documents. So when you talk about our disclosure of the actual cables, you're talking about a very small number.
It's publicized in the press that the American government is currently searching for legal tools to prosecute Julian Assange, and if there's going to be a trial, let's say, and if this trial is going to, it will go to the Supreme Court, do you think this heavy burden, this big scandal will affect the way that the Supreme Court will interpret the First Amendment? Do you think that they are going to be more restrictive?
It's a very interesting question, and let me kind of take it in part. The U.S. government has announced it's looking at the possibility of prosecution. Most of the, my area is not criminal law, most of the prosecutors that are former prosecutors I know, including those from the Bush administration, believe that's a very, very difficult case for a variety of reasons. In part has to do with what I talked about with the Espionage Act being so confusing. Part of it has to do with the fact he's not an American citizen. Part of it has to do with the fact that what exactly he did remains a bit of a mystery, and then you throw in the First Amendment implications. The question, though, about where the Supreme Court go is very hard to call. As you know, the current U.S. Supreme Court has a fairly conservative majority, but has shown itself to be libertarian in many instances involving the First Amendment. The court, with a slightly different lineup, but with the conservatives supporting it, supported the right to burn flags, for instance. They gave, in recent cases, they have held in favor of the press, not necessarily the press, but in favor of free expression in 3 or 4 recent cases, all of them important. So it's very hard to predict where they are going on the First Amendment, but there's no reason to think that this particular court, despite its conservative bent, is hostile to the First Amendment.
As far as I know, in the Pentagon Papers report that was leaked, which was a report where U.S. diplomats discussed Wikileaks and what kind of a threat it could mean. Wikileaks was talked about as a journalistic outlet. The leaked documents that were leaked up to 2008 were talked about as if they were articles and news reports. And now you're saying that Wikileaks is not really seen as a journalistic outlet, and I'd like to ask what changed that.
Yeah, let me clarify that. I raised the question of whether it should be viewed as a journalistic outlet or not. The history of WikiLeaks, though, is that in its early days, if you look at the way it described itself, it did not portray itself as journalists. You know, that over time, over the last 6 months, they have changed their website. So they now refer to Julian as editor-in-chief. They talk about being a news organization or a press organization. I don't know this for a fact, but I know Julian's lawyers very well. They used to be our lawyers in England. There's no causal connection there. It's just that they used to be our lawyers, and I'm sure that their advice to him was to, for obvious reasons, to make it sound more like they're doing journalism. Whether they were or were not remains a question. My point here would be that if there is a way to distinguish Julian Assange from a reporter from the New York Times, someone's going to have a very difficult time making that argument. You may get into how he got the documents, that there may be some line that was crossed there. I actually feel that rather than arguing about who's a journalist and who's not, that it's probably wiser today to talk about what is journalism and what is not, because I think that, in honesty, there's a lot of websites which sometimes are doing journalism and sometimes aren't. And when they're doing journalism, I think it's a good public policy to defend what they do in the same way we defend the mainstream media. When they're engaged in other activity that isn't journalism, I don't think it's right for them to share in the protection.
So, thanks for the great talk, and I would like to stress the point and ask a question about legal protection for leakers. As you wonderfully put it, leakers are part of a civic conversation, and if they are threatened with punishment and prosecuted for leaking, even if it's in public interest and might get to prison, that can dry up sources for the press as well. And if that happens in one of the great democracies like the US, then in countries like Hungary, it makes it a lot harder to argue for press freedom, because those who want to restrict press freedom just can finger point and say, look, that's democratic too. So what's the problem with that? So how much chance do you think we have to establish the public interest test as a legal protection assessed at the end by courts for leakers, which would provide that if the leaking took place in public interest that overwhelms the public interest for classification, then no successful prosecution should be possible?
Yeah, I mean, I certainly agree with the idea that people who are charged with leaking should have as a defense that the disclosure was in the public interest. I mean, there are obviously leaks that are done for the wrong reason that do not advance the public interest. And I don't know of a principled way not to say that those people shouldn't be prosecuted. But I do think that leakers who leak in the public interest should enjoy a protection. And as Peter says, that's not currently the law in the United States. And I think it will be very difficult at this time to get U.S. courts or the U.S. Congress to accept that. I think that they are very concerned about leaks. And there's not really political will to change that. What's really changed, if I might just go another 2 sentences on this, what's really changed is that in the United States is that leakers come at this a different way. What's changed in the United States is that while leaking was illegal, prosecutors have not taken it seriously. You know, that usually a leak investigation ends with the prosecutor saying, I can't find who leaked the documents. And what's changed now is the Obama administration is very serious about bringing prosecutions against leakers. One of the cases involves a man named Jeff Sterling, who is a former CIA employee. He's accused of leaking material to a reporter who wrote a book about the CIA. He is not only charged with leaking the information, he is charged with mail fraud. What was his mail fraud? He bought the book that the reporter wrote and he sent it to a friend. Okay? Therefore, he used the mail service to help pass on his fraudulent activity, which was the cover-up of his leak. That's a very, very aggressive criminal charge in any case.
Hi. Thanks for the talk. I have a series of questions, but it all comes down to one question. I don't know if there is a competition for sources. I guess there is. And I don't know how you, whether you are able to judge that, but it seems that traditional media outlets are losing sources to WikiLeaks. Why do you think Bradley Manning or any other source that could leak those documents went to WikiLeaks instead of New York Times or Guardian in the first hand? And my second question would be, do you think New York Times should offer a service like WikiLeaks offers that lowers the barrier of entry for leakers to share secrets?
Good questions. I think that I don't know what Bradley Manning, I don't even know if Bradley Manning, it's never been proven that Bradley Manning was WikiLeaks' source, although that seems to be the case. I think that the appeal of WikiLeaks is that people believe that their confidentiality is more likely to be protected. You know, WikiLeaks grew up in the hacker culture, which was essentially a criminal culture. I mean, I don't think I exaggerate. Julian Assange went to jail for hacking, or was at least he was prosecuted for hacking in Australia, I should say. And you know, I think that they use technology that makes it less likely that electronic fingerprints will be found. They use encryption. They use what's known as Tor, the onion route, which is a way that you can send things on the internet and it's very hard to trace them back. So I think that some leakers think that a site like WikiLeaks is less likely to either be forced to reveal a source or inadvertently will reveal a source. And they're offshore, which also plays a role in it. They're hard, you know, they're in Iceland, they're in Sweden, they're wherever they are. The second question is, should the New York Times have something similar? And I share no secrets here. Our editor has said we're working on that. The so-called, what we think of as an electronic Dropbox, where people could send leaked documents and feel comfortable, relatively comfortable, that electronically it would be impossible to trace who they are. The problem we have, and this is really the difference between the New York Times and WikiLeaks, is our reporters believe that's not very useful if we do not know who the source is. That knowing who the source is helps us find out whether the documents are authentic, helps us find other information that we need to put it into context. So I know U.S. newspapers are going to be setting up their own WikiLeaks-like depository. I'm not sure, I'm fairly certain that they will not be doing what WikiLeaks does, and that is simply publish things that come in. The final point I'd make there is some of you may know that some of the dissidents from WikiLeaks are now opening OpenLeaks. If you've seen OpenLeaks, OpenLeaks says that it will not be in the business of publishing. It is in the business of accepting leaked documents and distributing them to mainstream media. That's what they're going to do.
Hi. Thanks for the talk, too. What do you think the whole conundrum, what kind of effect it can have on the preparations, on the long preparations of the Shield Law in Congress regarding the source protection issue?
Yes.
Thank you.
Yeah, as a good question. If you followed U.S. media law, in 2005, Judy Miller, the New York Times reporter, went to jail when she refused to reveal her source. Following that, there was a movement to to pass a federal law which would protect reporters. There currently is no federal law that allows a reporter to protect his or her sources. There are court decisions that have said that, but there's no federal statute. So Congress began in 2005 working on that. It got hung up initially on the question of who's a journalist. There was a great pressure brought by bloggers and owners of websites to be included, not so that the privilege would have, so that not only people who work for the New York Times, but people who work for a website could protect their sources. They got over that issue, and then the issue became, would it apply in cases involving national security documents? There was a long debate over what should be the standard when it was national security was at stake. We got over that hurdle. The bill looked as if it was going to pass. WikiLeaks has now made that very, very unlikely. The response in Congress has been that shield law is a bad thing until we figure out how not to shield people who are engaged in what they see as stolen documents and the like. So I'm not optimistic that it'll pass. I think the publicity from WikiLeaks has significantly set back the chances of that bill ever passing.
Thank you for your great talk. I have good news for you. It might be in the US, it might be not so good legislatively, but in Iceland, the Icelandic Modern Media Initiative, which is a spin-off and not really associated with WikiLeaks anymore, is really exciting and successful. Is this an option also for the New York Times? If you cannot provide the service in the US for different reasons, maybe it will be a perfect place for that Dropbox for you in Iceland.
Yeah, I mean, the Iceland thing is an incredible initiative to see a government that essentially is trying to make itself into a free speech zone. So far, and I hadn't thought about it in the way you thought about it as far as an electronic Dropbox. When it was presented, when it was initially presented, the idea was, should American media companies have their servers in Iceland? And most American media companies decided that because they had reporters and needed to have reporters who were physically present in various countries, that it wasn't as helpful as it was for websites, which didn't really have a human presence, if you will, around the globe. And so from our standpoint, there was a lot of interest, and then people decided it really wasn't for us. You know, we continue to, find ourselves getting sued for libel around the world. The United States, the situation is very good, one libel suit, as I mentioned, but over the last 2 years, we've either just concluded or currently litigating libel cases in Indonesia, India, China, Iraq, Greece, Germany, England, France. And as you can imagine, getting sued for libel in Iraq is a very mysterious legal proceeding. But we need to be in Iraq, and so we have to defend there.
How can you tell an authentic leaked document from a falsified one? So is there going to be a war of leakings now?
Yeah, and that really is the number one concern we have about doing, our own electronic Dropbox, is the question of authenticity. How do you know it's real? I mean, that's always been a problem with paper documents. Even in the old days, we have had emails that were given to us where the dates have been altered to make it look like somebody knew something earlier. The only check on that is really doing what reporters always do, is going to the company, hearing their side, checking out what they have to say, and trying to authenticate. But I do think that that's going to be a lingering problem with anonymous drops.
A couple of things, actually. Did you and the other publications that published stories based on the documents have to adopt any special protection measures as regards taking care of the documents when they're in your possession to prevent any outside agencies getting into your computer systems and accessing them and seeing what you had, whether it's government security agencies, US security agencies, hacker groups from abroad, or other governments, to see what you had and to see what you might be planning to release?
I don't have any knowledge directly of that. The New York Times editor, Bill Keller, has said that 3 computers, one in England, one in Germany, and one in the United States, appeared to have been the target of hacking, and that we're looking into it. As you can imagine, we have a fairly sophisticated security system simply because of our concern about our own publication, our confidential sources, and so forth. So we didn't do anything special, but it's certainly something that we have thought about. And in light of the threatened release by WikiLeaks of Bank of America documents, we're aware that companies, not just governments, but companies are subject to not only leaks but hacking attacks.
Sorry, one other thing. Can you assure us completely that the government didn't in any way guide your decision on what to release and what to publish about? They didn't suggest, okay, this area is okay, but stay away from this, stay away from certain figures, stay away from certain governments, certain leaders, and we won't give you too much trouble?
No, I wasn't at the table, but my sense of the people that were at the table is that, if anything, the government felt that we did not play ball enough. I mean, they felt we didn't do enough. Bill Keller has an essay, which is the Boy Who Kicked the Hornet's Nest, which is available online and also in our ebook about WikiLeaks, and he talks about that in there and gives kind of an account. But and he talks about 3 levels of concern. One is that the government had. One is things that would interfere and embarrass, because it would show how we actually talk about the leaders of other countries. That they never used, they never moved on that. The second one was where the government was able to prove to them that there was something sensitive, there's an operation or so forth. And in some cases, he says, they were moved by that. And then the third case was when it might put individual lives at risk. And whenever we believed that to be true, we did redact. Is it possible the government portrayed something as being really sensitive that isn't truly sensitive? Sure, but we really try to check that out. And that's no different than, when we cover things in Afghanistan and we're led to believe that coverage of a certain troop movement will in fact jeopardize lives or harm the effort. We take that seriously. We don't take it at face value, but we take it seriously, and we always reserve the right to make our own decision.
No, that's the last question.
Yeah, I would thank you first for coming to Hungary. And then the first question would be, you as a lawyer, what's like the most common advice that you give to your journalists which deal with a heavy case with a leaker or a whistleblower? And the next one would be a little more less off topic, because as we discuss the war of leaks and sources, I'm sometimes afraid that people will get numb from too much information, as we can see now in the internet. And how do you see yourself as an old school media, if I may say so, deal with this topic? And link with this question, what is your vision of law and media, I don't know, in a decade, perhaps? Thank you.
Yes, thank you. And I'm happy to be here. As some of you know, I was supposed to be here in January and was stuck on an airplane that never left the airport in New York, and to my disappointment. And I was glad that we were able to reschedule. It's amazing how much the world changes. When I was coming, Mubarak was the entrenched leader of Egypt, never to be moved, and now look at this. So thank you all for being here. To sort of approach the questions, in terms of advice to reporters, most of the, especially with dealing with sources, overall, I think the most important thing is to be skeptical. Sources have their own agendas. That doesn't mean their information is wrong. But, people who leak, it's not uncommon for them to be troubled employees, people who are being fired, people who are being accused of things, and so forth. And that doesn't mean their information is invalid, but you always need to check, you always need to take a look again. And we really push that. And try as much as possible to document what we're going to report through other sources. As far as the future of, I've been asked this question a lot, and I'm glad I don't have to decide what the future is going to look like, because it's very hard to predict. I think that it's possible. I mean, someone raised in an interview I did with one of a journalist today here, made a very astute point, which is maybe the U.S. government will actually do more about freedom of information. It may, in other words, make it easier to get documents legally. And I hope that's the lesson they take away, that there is a thirst for information, there's a demand for information, and our government should be more open. And why don't they change the Freedom of Information law so it's easier to get materials? I don't think that's the lesson they're taking away. I think they're taking away the opposite lesson, which is to put up the barricades. We need to do more to be more secret. As far as the bigger picture on too much information and so forth, I'm deeply concerned that the amount of information out there will continue to erode the financial basis of mainstream media. As you know, papers like the New York Times, broadcasters like CBS, and so forth. You go down the list. Advertising revenues are down, subscriptions are down, and news gathering is expensive, and we need to have revenues to do that. And I fear that the value of content is being eroded online. And I think that would be a very, very bad thing. It's sort of the paradox of libertarian theory. Libertarian theory said, government doesn't need to regulate the marketplace of ideas as long as there's competition. There's incredible competition now. Libertarian theory also said a free press will be a watchdog on the government. You need to have big, powerful media interests to be a check on big, powerful government, okay? Facebook will not be a check on government, okay? It'll do a lot of good things, but it will not be a check on government. So I'm concerned about that the content will be, will not be valued properly. I don't know what the answer is to that.
Thank you very much for this evening, and when we lift that curtain of secrecy, there is a small reception behind it, hidden, and so we can continue our conversation there. Thank you very much once more.